please read that motion?
Jaker object to the Illinois State Police rulemaking titled the Firearm Owner's Identification Card Act because the rulemaking does not meet the criteria under 1 Admin Code 220.900A2E, which requires a rule to be simple and clear so that the rule can be understood by the persons and groups the rule affects. The rule contains definitions that are subjective and open to broad interpretation by an enforcing jurisdiction, which leaves the regulated public without clear direction on how to comply with the rule.
By a vote of 6-5, that motion passes.
That is the Joint Committee on Administrative Rules with a motion to object to the state's gun and magazine ban rules that were filed September 15th with second notice rules filed weeks before the January 1st deadline to register banned items, and Illinois State Police filing those rules and getting tons of questions. But whether or not there was clarity in those questions, some may differ. Welcome in, Bishop on Air. I'm Greg Bishop as I broadcast each and every weekday morning here on YouTube, X, and Facebook. So I appreciate you guys tuning in. Be sure to like, subscribe, and hit that notification bell. And also follow me on X for real-time developments on all of these issues and more. So let's get into it. Yesterday, the Joint Committee on Administrative Rules was set to meet at 10:30, and they didn't actually get to doing business until about 12:30. And you'll hear a little bit from the Democrat co-chair, State Senator Bill Cunningham, as to the criticisms of them doing these things behind closed doors only to come out into the public view to ask specific questions. So we don't really get to see how the sausage is made as one would think you would want to see from a transparent state government. So we'll hear the response to some of those criticisms. But really, the meat and potatoes of this is the stack of questions that still remain for Illinois State Police as they put together these rules for the gun ban registry. Brief background: here in the state of Illinois, January 10th, 2023, at the tail end of the previous legislative session, Governor J.B. Pritzker enacted a gun and magazine ban and also a registry. And then flash forward, you've got lawsuits that were filed in state and federal courts. All of the wrangling that happened there still in federal courts. We've got later on this week a response the state is required to give to the Langley plaintiffs in the Southern District of Illinois federal court on a challenge of the Fifth Amendment issues, but also you've got the merits of that entire case moving forward with Judge Stephen McGlynn denying a stay on the proceedings. And some of the plaintiffs' groups actually wanted to go to U.S. Supreme Court to have their questions heard there. So the court's still dealing with this, but while there's no definitive outcome upon any kind of appeals there may be, even all the way up to the U.S. Supreme Court, rules for the gun ban registry being hashed out. So again, the law is enacted, lawsuits filed, and then October 1st, you have the gun ban registry opened up from rules that were filed on an emergency basis 2 weeks earlier. And then those rules were debated. You had several public hearings go on throughout the months leading up to that January 1st deadline to register. And then the registration rates, by various accounts, either 1.2% of total FOID card holders complying, or upwards to 4 to 8% of gun owners complying, which leaves a 92 to 99% non-compliance rate. So obviously there's still a lot of either uncertainty about this or just clearly people denying to take part in this, what they see as an unconstitutional law. So let's get to it. With the Joint Committee on Administrative Rules yesterday, State Representative Ryan Spain, the Republican co-chair, he had a slew of questions for the Illinois State Police Council and also for the Illinois State Police Firearms Bureau Chief. And here's some of the Q&A that transpired yesterday.
And if something were to happen in the future where PICA would no longer be applicable, we've have language that you have drafted this morning that speaks to the record retention provision of individuals who have completed an endorsement affidavit.
Yes, I believe that this morning I sent language to the executive director that would agree that upon a final order subject to all appeals or a destruction order from the Secretary of State, we would destroy any records. Otherwise, they would be kept in accordance with the State Records Act.
On the record, the department is in agreement with the language that you sent 11:37 this morning.
Correct.
Okay.
So I think it's important to note, again, they met at 10:30. That was the opening of the meeting. They weren't there. And an hour later, they ended up, filing some, last-minute questions, as you heard, 11:30 or so. And then that dealt with record retention. And if the case was to ultimately get to the U.S. Supreme Court and they were to strike down the Protect Illinois Communities Act, what would happen to those who are already registered? And state police say that some final last-minute language they were able to get together said that indeed, if that's the case and the courts shoot this law down, then they can go through the proper process of destroying those records. Next up, what about the law enforcement agency database, LEADS? I think that's the acronym. But that's what, law enforcement use if they pull somebody over. They check the license plate, and then you pull that license plate, connect it with whoever the driver could be, and you get a whole list of information about that driver, past criminal offenses. But also, it's going to also include whether or not somebody complied with the gun ban registry.
One of the questions that has come up is with regard to exempted individuals. Is there any record for exempted individuals within LEADS?
The simple answer is no. There would not be a LEADS entry that someone is exempt from completing an endorsement affidavit.
So then my question is, if an individual who is exempted is stopped by law enforcement, what's the guidance that you're giving to both law enforcement and these exempted individuals to furnish proof of their exemption?
I believe we referenced that in the rule as proof of eligibility for the exemption, and we defined what proof of eligibility meant. So the person would need to present that proof to law enforcement as defined in the rule.
So again, if somebody gets pulled over and they're part of this exempt class, state police saying that they have to provide proof that they're a law enforcement officer. But what about that LEADS information? Is it going to include not just whether or not they registered, but how many firearms they registered?
And is there any differentiation also within LEADS if someone has registered and filed an endorsement affidavit for not a firearm, but for ammunition, for example, or some part or accessory? A lot of the definitions have been confusing for people. Is that delineated within LEADS? What will be noted for law enforcement officers under that scenario?
Law enforcement will simply know that the person has complied with the endorsement affidavit provisions and that there is an endorsement affidavit on file. It will not, and I'll let Jeff correct me if I'm wrong, it will not tell them whether it is a firearm or an attachment or a 50 BMG cartridge. It will simply say that there is an endorsement affidavit on file.
So getting a bit of clarity there on whether or not the LEADS information for police is going to include, the number of firearms that they registered. So if you're found with, say, 2 long rifles that are categorized as assault weapons, is police going to be able to see that both of those are registered or just one's registered? But apparently all it's going to say is that they have filled out an endorsement affidavit through the Illinois State Police portal. What about using that information as probable cause? A question that State Representative Ryan Spain, the Republican co-chair, asked State Police yesterday.
Are there any probable cause considerations if you see someone has an endorsement affidavit, you don't know what it's for? Could be a firearm, could be a component, could be ammunition. What, from a law enforcement perspective, what is then triggered in terms of probable cause, for an individual in that situation?
Well, at this time, there would not be an easy access for, let's say, an officer who had pulled somebody over to quickly obtain that information. It would have to go through assuming a legal process of some matter, a subpoena to try to see if we can obtain that data for them.
So the presumption would be that they are in compliance with the law and that the exemption should apply to them. And if the law enforcement officer has some other basis to request that additional information, if there's some reason that they believe that that the person is not compliant, then they would have to seek that information like through a subpoena or some other lawful measure.
So in a different example, then, if you were stopped and you had 2 long guns in your possession, the law enforcement officer doesn't know if They know if you've completed an endorsement affidavit or not. Not, if it's for multiple firearms or only components or things like that. Correct?
Another question that was brought up was the registration and whether or not somebody has to have it listed as them registering a firearm that they may have sold. Here's, again, Ryan Spain.
If someone has completed an endorsement affidavit, but they have removed their possession of a firearm, sold it to a FFL, for example, is there a way to get yourself off the list so that you're not being tagged with this information?
If a person sells their firearm, I believe the statute requires that they make notification to the state police that they have sold the weapon, transferred the weapon, relinquished possession. And then that would be noted within their FLAIRS account.
So then that tag in leads would be removed.
Correct, because they would no longer be in possession.
And then the final question dealt with the federal 4473 form, and that's a form that potential gun owners fill out in going about buying a firearm, and that's a federal form. But Spain wanted clarity on how federal firearms licensees interacting with that federal form should be interacting with Illinois State Police.
Yes, and we received a question. So what we had asked is that I don't remember what form it is now. The 4470, the ATF's form 4473, that information be attached to it, and there was a concern about whether that was permitted under federal rule. And so we reached out to our counterparts at the ATF, and they indicated that is permitted by their rules and that they did not see a problem with that, and that would allow for consistent record keeping. Okay,
so I've heard that the ATF wants clean documentation that may not contain additional endorsements from the state of Illinois. Can those issues be handled separately then?
Well, we would not be altering their form. We indicated that it should be maintained with it, and the ATF indicated that they didn't see a problem with that. We're not directing FFLs to alter the federal form. We're asking them to keep the Illinois record with the federal record.
So, again, those are just a list of the questions that State Representative Ryan Spain had for Illinois State Police in the latest JCAR hearing about the gun ban registry rules. And then Spain, he went on and shared his frustration with this whole process.
We've been at this subject for a long time. We were all gathered here as a General Assembly 1 year ago, before the start of the 103rd General Assembly, when this legislation was passed. It's highly complicated. It's certainly controversial. And it has been filled with a lot of frustration. And I appreciate the great work that the state police does. This wasn't something that you initiated, but the timing here has been filled with problems. The filing of your emergency rules, the timing of the proposed permanent rules. I mean, we were getting these rules really shouldn't have even been allowed to be presented on the JCAR December agenda. And here we are now in January, after the first of the year, wondering where things stand. And I'm really quite frustrated that we could have approached this differently with a clearer time frame and trying to resolve many of these issues much earlier on, so that firearm owners throughout the state of Illinois, trying to understand this very complicated and conflicting legislation in many ways, could have had a better guidance on what they need to do.
So again, Ryan Spain sharing his frustration just before making a couple of different motions. The first motion was a motion to prohibit the rules from going into effect.
I would ask at this time for a motion to prohibit these rules from going into effect.
JCAR object to and prohibit the Illinois State Police rulemaking titled Firearm Owner's Identification Card because the rulemaking does not meet the criteria under 1 Admin Code 220.900A2E, which requires a rule to be simple and clear so that the rule can be understood by the persons and groups the rule affects. The rule contains definitions that are subjective and open to broad interpretation by an enforcing jurisdiction. which leaves the regulated public without clear direction on how to comply with the rule. JCAR finds that these provisions pose a serious threat to the public interest.
So this particular motion would have prohibited the rules from going into effect. And just a little bit of background on the Joint Committee on Administrative Rules, it is a bipartisan group, meaning equal parts Democrats, equal parts Republicans, 3 from each chamber, from each caucus. So I think there's 12 altogether. They only had 11 there, so there were 5 Democrats and 6 Republicans. But a motion to prohibit the rules from going into effect requires a total of 8 votes in the affirmative, not just a simple majority. And that motion to prohibit the rules from going into effect did not get that 8-vote threshold. It was only able to get 6 votes from the 6 Republicans. But a second motion was brought forward to object to the rules.
Please read that motion.
JCAR object to the Illinois State Police rulemaking titled Firearm Owners Identification Card Act because the rulemaking does not meet the criteria under 1 Admin Code 220.900A2E, which requires a rule to be simple and clear so that the rule can be understood by the persons and groups the rule affects. The rule contains definitions that are subjective and open to broad interpretation by an enforcing jurisdiction, which leaves the regulated public without clear direction on how to comply with the rule.
By a vote of 6 to 5, that motion passes.
So again, they officially objected. There were enough Republicans to outnumber the Democrats present at that bipartisan JCAR hearing to pass a formal objection that says these rules are not clear. So that is a legislative body saying that these rules are not clear. While that doesn't prohibit the rules from going into place, it does require that state police have to come back and answer more questions. This is going to be a little bit of a longer segment because I've also got reaction from yesterday's JCAR hearing. Democrat State Senator Bill Cunningham, he reacted to some of the outcome and ultimately what happened at the JCAR hearing.
Therefore, the panel agreed to put the permanent rule on our omnibus no objection list. So that went forward. That permanent rule will go into place right now. We have a pending objection to the emergency rule that will require the state police to come back and address that at our next meeting.
So the second notice rules, Cunningham said, are in place.
So there was a second notice agreement that adopted that aspect you heard the discussion about document retention, that was part of a second notice agreement between the committee and the department.
So that second notice agreement, again, touching on a variety of things, but ultimately those rules going into effect and staying in effect, from the emergency rules to the permanent rules for the state's gun and magazine ban. But somebody did ask about that 2-hour delay where JCAR was apparently meeting behind closed doors, even with last-minute language being brought forward that they would agree upon. Here's Cunningham.
Well, you heard the discussion occur here in the motion at the committee, okay? That's why we call them up to the table to discuss the proposed rule, change to the rule, an amendment to an existing rule. So when we do that, we have the representative of the agency come forward and give testimony to that effect. So it is done in the open before a vote is taken.
So Cunningham, again, being asked a series of questions after the JCAR hearing, including a question from another reporter about does the objection that did pass mean anything?
As I said before, I think the best way to look at it, it is a way for the majority of the members of the committee to get on the record stating their displeasure with the rule. It just requires them to respond in writing.
And the objection was to...
So again, an objection officially passed, and Cunningham saying that just allows for the majority of the members to have their objections officially on the record. I've had others indicate that while the objection does not block the rules from going into place, that official objection by a legislative body saying that the rules are not clear for the public to follow can be used by a court. They can point to that and say, clearly, there's confusion. A legislative body said this is confusing. confusing. So maybe this official on-the-record legislative action about the gun ban registry rules could be utilized in a court of law. So it'll be interesting to see how that plays into it. But I asked the leader about the compliance rates. And of course, the January 1st deadline came and went, and of 2.4 million FOID card holders in the state of Illinois, only around 30,000 or so, which is 1.2% of FOID card holders actually filing an endorsement affidavit telling Illinois State Police they have a banned item. Here's what Senator Cunningham had to say in reaction to that.
I don't believe that was addressed in the rule. I would need to check on it, but I don't believe that was addressed in the rule.
What's your reaction to the registration rates, which are anywhere from 1.2% of FOID card holders, or others are saying it could be 4 to 8% of total, either way, 90% non-compliance?
I would say this, Greg, I'm a law and order guy. I think people should follow the law.
Obviously, there's been many counties across the state that sheriffs said that they're not going to be enforcing this. What are your thoughts on that, the fact that this is yet another law, that there are sheriffs that are on the either side of, am I going to enforce this or not?
Again, I will say I am a law and order guy. I think people should follow the law, including various sheriffs. Now, there's some subtlety in that, of exactly how you enforce the law, whether you are affirmatively going out and enforcing the law or enforcing it when you come across a situation when you find someone to be in violation. I don't know that in the latter example, so many sheriffs are going to refuse to enforce the law, but I think they should. I think anyone who believes in law and order should enforce the law of the land.
But with 90% though saying that they're not, or they haven't complied for whatever reason, be it's confusion about the rules, or maybe they just didn't know about the registry.
Ignorance.
What does that say to the validity of the law if people who are impacted by this are not going to enforce or not going to comply?
Well, ignorance of the law is never a valid excuse for not following the law. Again, I would just say the law is the law, and I think people that believe in law and order should follow the law.
So Cunningham, again, being asked a variety of questions after the meeting. And there was also a question about do any laws need to be passed to maybe clarify some of these things that are still very much up in the air and questioned by gun owners across the states?
I believe that during the back and forth, while these rules were on second notice, the state police made a number of good adjustments to the rule, and I'm satisfied with the shape the rule's in right now.
And again, just a final thought here from the Democrat co-chair of the Joint Committee on Administrative Rules, State Senator Bill Cunningham.
Well, it's a very complicated law. There's no question about that. So it's understandable that there would be confusion. Hopefully, some of the changes that have been made in rule addresses the confusion. I think the state police has also put on their website a frequently asked questions page that I also hope will help answer some of those questions. I can't say that it will answer all of them. It's a very complicated law. There's no question about that, and the confusion is understandable, but I think there's been a good faith effort made to try to address some of the confusion.
So again, the final outcome yesterday was that an official objection from the Joint Committee on Administrative Rules passed, and that's being put on record. JCAR meets again next month, I believe February 6th, where it's expected Illinois State Police will have to come back and answer some more questions. Illinois State Rifle Association's Ed Sullivan was in attendance, and I asked him afterwards his reaction to what happened.
Well, what happened today was the Republicans tried last-ditch effort to end the rulemaking and the Protect Illinois Communities Act and the endorsement affidavit. They failed. They put a great effort forward, but according to the rules, because they couldn't get 8 votes, the emergency rules are not going to become permanent rules moving forward.
So the questions are, we heard earlier from the retention of these documents, and if the law is struck down, would those documents be destroyed? Sullivan saying yes.
Right. So we did see the language that they have produced in response to what happens if, and that what happens if is if the U.S. Supreme Court would strike the law down. And would they destroy those records? And what the state police have said, once all appeals are exhausted and there's a court that federal or state orders the destruction of the records and the state records department says you can do it, then they would destroy the records. And so that's a win for law-abiding gun owners.
But what about that 4473 question that was brought up during the JCAR hearing? Sullivan reacting to that.
It's an odd little discrepancy that the FFLs of Illinois really wanted to know what is their requirements under record keeping. And so they wanted to make sure that the things or the documents that the state police wanted them to keep did not interfere with their federal rules that in essence could affect their livelihood. And so they just wanted clarification for that.
So Sullivan also providing some final thoughts here on next steps for this as the laws are now in place.
Well, no, I think right now the rules are the rules. And so we know what the playing field is going forward. They're still kind of screwed up. I don't think they were ever going to get clean rules, quite frankly. And that isn't the fault of the state police. That is the fault of the people that wrote the bill. That is just a horrific attempt to, hurt law-abiding gun owners.
So again, just a recap of yesterday's Joint Committee on Administrative Rules hearing here with Bishop on air. Appreciate you guys tuning in. Like, subscribe, hit that notification bell for the latest as I do this each and every weekday morning, hanging out with you before I head off to the state capitol to cover what's going on there. Follow me on X, follow me on Facebook, and of course, like, subscribe, and hit that notification bell here on YouTube. All right, appreciate you guys tuning in.